Yes, Mr. Bastin.
My lords, my lady. In my submissions this morning, I will start with some brief introductory remarks. I'll then come to the legal principles, and then I will turn to the draft order that the Czech Republic proposes. I will then turn through the award as it will be affected by the draft order, and at the end deal with some disputed points between the parties as to the order. As I say, I will come to the legal analysis and other points in a moment. But there are a number of background features which are relevant to mention by way of introduction. They are relevant in my submission because they have a direct bearing on how the court should exercise any discretion it has in the circumstance of this case in relation to the terms of the order. And I start with this. It is, in my respectful submission, indefensible for Mr. Stava to say that, despite the fact he gave away his shares in Diag Human for tax planning and asset protection purposes, he actually still gets 100% of the BIT award, even though it has now been found that there is no jurisdiction over Diag Human. In my submission, the court ought not, in fairness and justice, now allow a situation whereby Mr. Stava still retains all the benefit of the shares in Diag Human that he alienated for the purpose of this award. And that is especially so when the damages being awarded are calculated solely by reference to a commercial arbitration award to which Mr. Stava was not a party. As the court knows, this is a very substantial award. The sum stands at over $750 million at present. And that sum was arrived at by the tribunal without any independent analysis and quantification work at all. This award, as the court will recall, in its award of damages, in essence lifted the damages from the commercial arbitration award issued in 2008. Yet, Mr. Stava, as I've said, is not a party to that 2008 award, and he is the only claimant now who can be said to establish jurisdiction under the award.
Well, they found that he was privy to the award, didn't they?
They found that he was a privy for the purposes of Diag Human being the entity that moved forward, but not a party to the 2008 award, my lord. So in those circumstances, the jurisdictional finding of this court means that only Mr. Stava can be said to fall within the jurisdiction of the BIT tribunal.
It went a bit further than that. It wasn't the finding that he was a privy and that therefore he could not claim any more than the amount of the award. So he was bound by the award in that sense.
It was a ceiling, you're right, my lord. So in that sense, the approach of the tribunal in saying that the 2008 award would be recognised as a matter of international law imposed a ceiling on what the owner of the claimant company that was party to that award had been entitled to. And indeed, Mr. Justice Foxton below made exactly the same point. In his lordship's terms, he said it would be utterly incoherent for Mr. Stava to be entitled to more by way of damages in the BIT arbitration than the company was entitled to. And with respect, the point that the court has alighted on, which Mr. Justice Foxton emphasised in strong terms, is an important one. And it's an important one because here we are now in a position where it is crystal clear that Diag Human is not entitled to any award of damages. There's no jurisdiction for the tribunal to give it those damages.
It doesn't mean it's not entitled to the money.
Under the 2008 award, that is...
Under if one started completely afresh, it would be perfectly possible that Diag were entitled to damages in that amount.
So, my lord, there is a separate debate between the parties as to what Diag Human can do in relation to the 2008 award and the amount that has been ordered by that commercial arbitration.
I'm on a slightly different point. Leave aside the 2008 award. It would have been open, wouldn't it, to the tribunal to say, we don't have any jurisdiction to award anything in favour of Diag, but we do have jurisdiction to make an award in favour of Mr. Stava. And in order to decide what the appropriate award in favour of Mr. Stava is, we are going to consider what damages would be recoverable against Diag. It wouldn't be assuming jurisdiction. It would just be the usual case of a tribunal saying, in order to decide something, we've got to decide what the position of a non-party is.
With respect,
Is that right?
With respect, my lord, no, I do not accept that is correct.
Right.
And the reason I do not accept that is correct is that if there is no jurisdiction over Diag Human, the only asset which the company Diag Human had was the award. And Mr. Stava has alienated his shares in that company. And so it cannot stand for him to make a claim under the BIT as a separate investor in circumstances where he has given away his shares in the company for which the only asset was the 2008 award. So in those circumstances, my lord, it would not be possible for the tribunal to reason through damages in the way that you summarised a moment ago.
But isn't that a,
why? Sorry, I just don't follow the logic of that at all. Let's break it down for me, because it sounds to me like it's apples and pears.
I'm very happy to break it down, my lady. So in circumstances where the commercial arbitration award is an asset of the company, Diag Human, and Diag Human is a separate investor under the treaty to Mr. Stava, the only way in which Mr. Stava could have an entitlement flowing from the 2008 award is if Diag Human as a company was a company in which he retained an interest in the form of those shares.
But Stava isn't claiming an interest in the award. Stava's claim is that he has suffered damage which is quantified as the same amount as was quantified in the 2008 award in favour of Diag. He's not claiming an entitlement to the award.
You're quite right, my lord, he's not claiming an entitlement to the award, and that's why I said his only entitlement is what flows from the award. And the distinction I'm drawing there is important, because Mr. Stava's claim as an investor under the treaty was on the basis that he held shares in Diag Human. And holding those shares is what entitled him to appear as his own claimant in the arbitration, and the control that he said those shares allowed him to exercise over Diag Human is what allowed it separately under a different paragraph in Article 1.
but isn't that a merits point? Suppose Diag had never been a party to the BIT award, which is perfectly possible. Mr. Stava brings the claim. He makes his claim by reference to things that have happened regarding a non-party, Diag, and there is an issue whether he has lost the benefit of the claim that he would have had by reason of alienating his shares, and the tribunal make a decision about that, and that's a decision on the merits, which, whichever way they go, is not appealable or not reviewable. Isn't that a valid analysis?
So with respect, my lord, that may well have a merits component to it, but that would be one of those issues where there is also a jurisdictional component to it. And the reason for that would be that if Mr. Stava has given away his shares, that therefore means that there is no status that he can claim as an investor under the treaty. The alienation of the shares is a critical point on jurisdiction. Mr. Stava, unless he has those shares, in our respectful submission, is not entitled to any damages because he is no longer a shareholder in a company that has an asset that is covered by the treaty.
Haven't you lost that battle? I'm sorry, I'm being rather slow. Haven't you lost that battle with the court's findings on jurisdiction?
So the court's, my lord, with respect, the court's findings on jurisdiction go to whether or not Mr. Stava was an investor, and that is a point which I agree has been determined. But what we are saying here is that this has consequences which go through to the damages part of the case. So even though it has a merit/damages component to it, The reason I'm making this point is simply to elucidate that it does have a jurisdictional element. And indeed, it's quite an important point to emphasise, because we'll come to paragraph 414 of the award later this morning. And that paragraph is essentially saying that the standing objection that the Czech Republic had taken in relation to Mr. Stava and Diag Human was being dismissed. But one consequence of this court's decision, in my respectful submission, is that if that paragraph is to say that the Czech Republic is not entitled to say that Mr. Stava does not have standing in circumstances where there's no jurisdiction over Diag Human, then that is a point which on remission ought to be open to the Czech Republic as a consequence of this court's judgment. So I agree, my lords, my lords.
You took that slightly too fast. Just repeat the last bit, please.
I apologise, my lord, and I am jumping forward somewhat in my submissions in doing so. Paragraph 414 of the award is that paragraph which comes at the end of the reasoning on jurisdiction. The court may remember that paragraph 413 was the one line which said, yes, if it's helpful, we can turn it up. I think you have a supplementary bundle which contains the award. And the reference for the operator is A3/8/126. This is on page 126 of the award. Oh, pardon me, yes, it's SB is the correct bundle, I'm grateful. Now, we'll come to turn through this award in full, of course, later on, but if one starts at page 122, one sees this is where the jurisdictional objection number 5 is dealt with, whether the claimants can be deemed investors of the other contracting party. Now, as the court will recall, Mr. Justice Foxton looked at these paragraphs in some detail and said they apply to both claimants. They apply to both Diag Human and also Mr. Stava. That reasoning covers up to paragraph 413, which is on page 126. We'll come back and look at that reasoning in more detail. But 413 is where the court dismisses that jurisdictional objection. Now, I'll come back to this point again, my lords, my lady, but the first sentence in paragraph 414 is a submission, or a finding, I should say, about the standing point being dismissed. Now, that standing point is one that we say will necessarily have to have some reconsideration consequential on the court's judgment. So the questions that have fallen from the bench this morning have, in my submission, alighted upon this point about whether or not there is both a jurisdiction or standing element to Mr. Stava's ability to claim or not, as well as a merits component to it.
The difficulty I'm having is understanding why you say we have to revisit standing, when standing is here part of a jurisdictional objection, and we have now finally determined, subject to an appeal from us, that that jurisdictional objection is unfounded.
And so, my lord, entirely so, but having found that that jurisdictional objection is unfounded, what must fall from the jurisdictional objection that this court said was founded is that paragraphs 395 to 413 that we just looked at fall away, they cannot stand. And that being so, in our submission, the first sentence of paragraph 414, which applies to the standing point, also must be open for reconsideration by the tribunal as well. That's a necessary corollary of it. Now I'm going to come to
397 says that Stava meets the definition of investor in Article 1.1,
yes.
and that's nothing has happened since to change that.
And my lord, what I would take the court through when I come to the award, sort of mid-morning if I may, is that as one comes through these paragraphs in the award on jurisdiction, in my respectful submission, they cannot stand. And the reason they cannot stand is that they are not severable or separable as between the two claimants. They are bound up as a unitary set of reasoning that applies to both claimants. Now, I'll come to the law on severability in just a moment. That's the first point I was going to take after introductory remarks. But when one works through those legal principles, my lord, in my submission, it is really quite clear that these paragraphs on jurisdiction will need to be varied directly by the court. In fact, if it helps deal with that point briefly now, I will say that there is a number of cases that are before the court that make it clear that in the context of an arbitration award, if the bad part of an award is not separable from the good part, then both parts must fall together. There's a number of cases I'll take the court to later, but that being so, my lord, in my submission, it's not possible to pick out on a party-by-party basis some findings in the court's reasoning on jurisdiction and preserve other findings on the court's reasoning on jurisdiction. Indeed, the way in which the defendants' draft order has sought to try and square that circle only highlights that what one would be left with is an incoherent award that has contradictory statements in one paragraph followed by the next. Now, as I say, I can come to that in more detail as I come. There is one small point in response to my Lord Justice Popplewell's question, which I should clarify, which is that in the underlying arbitration, Mr. Stava was claiming payment of the award as such. So before, when I indicated that he was claiming flowing through from the award, I actually can and should have put it slightly higher than that, which is that his claim in the arbitration was a direct claim for payment of the 2008 award as such. And part of the reason why the Czech Republic is focused on these points is because of just how significant the award is. I've already referred to its value, but this is also an award which is made up of an enormous amount of interest. Nearly 3/4 of the award is interest that has accrued since 1992 at a rate of 12.5 to 15%. And indeed, a point that the court may not have had in mind, which is not disputed, is that it is very hard to reconcile the BIT award with the 2008 award from which it lifted the quantification of loss. Just to take one example, the court will recall that the BIT tribunal held that the Czech government was entitled to order hospitals not to contract with Conoco, Conoco being Diag Human's predecessor. By contrast, the 2008 Commercial Arbitration Award awarded damages based on an assumption that Conoco had won tenders and had achieved a certain market share.
Well, whatever the significance of that may be, that's long since water under the bridge, isn't it?
Well, the reason I am alighting on these points at the outset of my submissions, my lord, is simply to frame the points that are going to come later. And the reason why it's important to frame them in that way is that the court has before it two very distinct approaches between the parties. On the one hand, the Czech Republic turns through the award and says the findings of this court on control affect certain parts of this award and they must fall, or at least be set aside by the court. And sometimes those findings in relation to Diag Human are mixed up in the same paragraph or the same line of reasoning with findings in relation to Mr. Stava.
Does it matter that for those purposes, the findings that this court makes are based on the evidence that was before the courts, whereas the findings that the tribunal made were based on the evidence that was before it? Assume that you just translate one into the other, so that our findings must be translated into the award.
No, it does not matter, my lord. And the reason for that is that my lord, is that under Section 67, the court is of course engaged in de novo jurisdiction. And in those circumstances, if the court has allowed evidence to be placed before it in order to determine whether a jurisdictional objection is good or bad, and determines that it is bad, then that objection falls. And when one then goes to the award to determine the effect of that jurisdictional objection falling, then what needs to be either varied or set aside and remitted are all the consequences of the court's de novo determination that the jurisdictional objection is correct. So in those circumstances, even if there is a difference of evidence, and I must say I cannot immediately think of one that would be relevant on this particular point that we're discussing now, that doesn't change the fact that as part of its supervisory jurisdiction, this court is properly, in my submission, either to vary or set aside the paragraphs in the award affected by the control determination.
Well, I think you can take it, Mr. Bastin, that this court is going to take a lot of persuading that we should be going through the award, looking to see which paragraph should be rewritten or which should fall away in light of what we've decided. That doesn't seem to be a suitable task for us. You can seek to persuade us otherwise, if you like, but at the moment, the points which are really interesting us are what should happen, if anything, to the damages award in favour of Mr. Stava in the light of our conclusion about no jurisdiction over Diag, and if anything should happen, who should be making that decision, whether it's us or whether it's, I think the judge was canvassed at some point, but
I think that's fallen away.
has fallen away, or whether it be remitted presumably to a new tribunal in the light of what we've been told. Similarly, what should happen to the costs award, if anything, and what should happen about the undertaking. I mean, there are other points of detail we'll need to consider, such as whether anything which we order should be stayed pending any application for permission to go to the Supreme Court. But those really are the big picture items on which we would welcome your help, and really why we have agreed to the suggestion that we should have this oral hearing. So I think we'd be helped if you can focus there.
Thank you, my Lord, I'm grateful. If I can seek to provide a summary answer now, but then, as the court will see, the large bulk of my submissions are geared towards exactly those types of points. And the summary submission now is that the Czech Republic does maintain its primary case, that it is possible to vary the award by this court. But if the court is not minded to vary the award directly, then it ought, in our respectful submission, at a minimum, set aside or declare of no effect those paragraphs of the award that are affected by the court's findings on the third appeal, the control point. And the reason why that is appropriate in my submission is that that is a proper exercise of the supervisory jurisdiction of this court. Indeed, it was not within the parties' agreement to arbitrate that the tribunal would set aside or declare of no effect paragraphs in its previous award. The interplay between the supervisory jurisdiction and the jurisdiction under the arbitration agreement is such that the court ought to be the body that says, we have determined that this jurisdictional objection is good, and when we review the award, these are the paragraphs that are affected, that are bad as a result of that. Now, it is then, of course, for the tribunal, once that has been identified, to set its procedure for how it will go ahead and to make determinations on the merits. But in my respectful submission, the preferable approach is what the Czech Republic has set out, either in its first alternative or option A of its second alternative in its draft order, which involves the court exercising that supervisory jurisdiction and setting aside or declaring of no effect the paragraphs affected by its finding on the third appeal. Now, under the Czech Republic's draft order, the court will have seen that there was also option B in the second alternative. And that option B is where the court does not say these paragraphs are hereby set aside or declared to be of no effect. However, even in option B, as the court will have seen, the Czech Republic proposes that there should be a clear explanation as to what the consequences of the court's findings are. So even if there's not a formal set-aside of certain paragraphs, there is still a clear explanation that the tribunal cannot go ahead and make determinations that are in effect contrary or not circumscribed by the finding of this court on the third appeal.
I'm sorry to keep interrupting you.
No.
But what do you mean by declaring that reasons are of no effect?
I mean,
reasons only have effect for the purposes of a challenge under Section 68 or Section 69 in substance. It's the depositive part of the award which otherwise has effect, and again, Section 68 and 69 are all water under the bridge. So why should we be trying to ascribe effect or non-effect to reasons?
My Lord, a entirely fair point. The reason why the Czech Republic has put either set aside or declare of no effect is that in some of the cases there has been language talking about the ability of the court to declare a paragraph as having no effect. However, as the court will have seen from the Czech Republic's draft order, our primary formulation is simply set aside, which is of course reflected in the language of section 67 of the Act.
All right. But if it's irrelevant, whether the reasons are to have effect, because we're not concerned with the effectiveness of reasons, what is the purpose of setting aside parts of the reasoning rather than just dealing with the dispositive parts of the law?
The purpose of the setting aside is, whether one takes the Hussman approach or the court directly regulates the matter by way of an order, is to allow the tribunal to say that part of the award has been set aside pursuant to the supervisory jurisdiction of the court. And we now need to go ahead with a fresh procedure to determine the merits in light of those paragraphs being set aside. What the court ought to do in those situations is explain what the consequences of its judgment is to the tribunal and give either the guidance through direct order or through set aside, which allows the tribunal to make its determinations on the merits properly circumscribed by the consequences of this court's finding. So in those circumstances, we do say that it is quite important that what is before the court, as the arguments supporting the different forms of draft orders, are two very different approaches. The defendants say that the award stands unaffected in relation to Mr. Stava. And that is even though, and we'll come to this as we turn through, the award's reasoning cannot logically stand following the court's findings on Diag Human. It's an important point to recall that Mr. Justice Foxton, in the August judgment, stated that the same ownership and control findings that this court has now determined must apply to both claimants as a requirement of consistency and justice. That's at paragraph 250 of the August judgment. We'll look at it later. But his lordship was very focused on this point. He was focused not only in his judgment, but certainly in the exchanges with the parties. And his lordship was focused on it to the extent that he required express undertakings to the court as between the Czech Republic, Mr. Stava, and Diag Human, that each would be bound by the fact findings as to ownership and control which he made on the part of the case which gave rise to the third appeal, which has ultimately been determined in the Czech Republic's favour. Now, it's not surprising at all that his lordship made that finding. After all, the reasoning of the award in relation to Mr. Stava and Diag Human is tightly bound up one into the other. We'll turn through the award, you can see that, but the jurisdictional paragraphs we've briefly looked at are a very clear example of how the tribunal was dealing with these issues in respect of the claimants together as a unity. As we will see, it would make the award incoherent in my submission, just to drop Diag Human out of it, as the defendants suggest. Frankly, where this problem comes from for the defendants with the formulation of the order that they seek from the court reflects a very significant underlying problem for Mr. Stava. And that problem is that, as regards the trust that he set up, he cannot, on the one hand, rely on it for inheritance planning and asset protection purposes, while on the other hand, insist on being treated as if he still owns and controls the shares.
Why would it not be open to the tribunal as a matter of merits to take a different view from this court on the question of effective control? Now, they can't do anything about the fact that there is no jurisdiction over Diag because we are entitled to say that they don't. And under section 67, subject to the Supreme Court, we are the last word on that. But the tribunal may have different evidence, or they may simply take a different view. And so far as the merits are concerned, they're the last word. So why shouldn't they say that if that's what they want to say? And isn't that what they have said?
So, my lord, in circumstances where the tribunal has been told you do not have jurisdiction over this party, in my submission, the tribunal is then not jurisdictionally competent to make merits findings that are outside the scope of that jurisdictional limitation. So if, for example, the tribunal said, we hear the court in saying we have no jurisdiction over Diag Human, but we are going to make merits findings that are directly contradictory to these court's findings as a matter of jurisdiction, then that would fall outside the scope of what the tribunal is jurisdictionally competent to do. In those circumstances, without anticipating any point, in my submission there would very likely be a form of Section 68 challenge at least in relation to a tribunal that exercised in its merits part of its decision a jurisdiction which the court was clear it did not have.
But I come back to my evidence point. Suppose on the evidence the tribunal had said Mr. Stava didn't in fact alienate these at all. He remained owner on the evidence they had, and that was their finding. And then on different evidence, the court said that is simply not a realistic finding, but on the evidence we have, he clearly did alienate it. And why in those circumstances does the effect of the court making its own decision on that evidence necessarily undermine from a merits point of view what the tribunal found and was entitled to find and hasn't been the subject of a Section 68 or Section 69 challenge on the evidence before it? I may only have just put the point to you again, but my Lord's question seems to illustrate the difficulty.
No, I certainly don't suggest that there is not nuanced decisions for the tribunal to make as to the procedure that goes forward after a remission. But the difficulty there, my Lord, if I may suggest, is that in those circumstances, the court has still determined the jurisdictional objection. It may have heard new evidence, and that's entirely proper under the Section 67 approach that Mr. Justice Foxton applied. But simply because the court heard new evidence and determined the jurisdictional objection differently to the tribunal does not mean that the tribunal's approach to jurisdiction is defensible on the evidence before it, or, critically, that its merits findings based on the evidence before it stand. If the evidence before the tribunal led it to make merits findings, which it held was within its jurisdiction, but that was then determined by the court to be wrong, then it's not simply the findings on jurisdiction that fall in the award, but also any merits findings based on whatever evidence was before the tribunal that is now outside its jurisdiction. There will be plenty of cases, my Lord, where this issue arises, where somewhat different evidence is led before the court compared to what was before the tribunal. Here, for example, on the control point, we have Liechtenstein law evidence, which was not before the tribunal. In those circumstances, because of the supervisory jurisdiction of the court being de novo, that is a determination of jurisdiction. But when I say determination of jurisdiction, it's important to clarify what that means for the tribunal. It means that the competence of the tribunal is circumscribed by the findings of the court. And that competence extends to its ability to make merits findings. So even if it had made merits findings based on different evidence, those merits findings are still outside the jurisdictional limitation that the supervisory court has confirmed binds the tribunal. So those merits findings, even if based on different evidence, which will be a very common case, must also fall. My lords, my lady, we've anticipated a number of the points that are going to be central to my submissions as we go through the morning. Can I turn now and spend a little bit of time on the legal principles? The question that arises is how one ought to decide if the court's findings on Diag Human affect Mr. Stava. And the legal test the Czech Republic says applies is one of separability. Now, the defendants do not provide any legal test for this issue. The defendant's approach is simply to say that you simply remove one party and any incoherencies that arise as a result of that are just there to be lived with in the award. As we will come to, that would simply lead to the court creating an incoherent award. Now, before I turn to the cases, I'd like to make some initial points around separability. Generally, this doctrine is English law's approach for whether you can separate out issues which have been tainted by a defect from those which have not. And the court will have seen this in many other contexts as well, not just in the context of arbitration challenges. Now, the Czech Republic contends that that approach of severability is also the correct approach here, having regard to the language of Section 67, the operation of Section 67 to 69, and the approach in the Act more generally. Now, sometimes severability can operate in favour of an award creditor. If there was no severability doctrine, then an award dealing with 2 points, one of which was made without jurisdiction, would simply fall as a whole. That's clearly a protection and a benefit to a creditor. But sometimes, as here, it does favour the award debtor, but only to the extent that the creditor then has to go back and remake submissions based on the correct jurisdictional limitations of the tribunal. Now, this issue of a partial excess of jurisdiction and the impact of parts of an award that are bad is not a new one. If the court could turn up the authority from Russell, which is in the second authorities bundle, I believe, I have one. If we can turn to internal page 430, you can see there that the learned authors deal in a passage of award good as the part only with the partial excess of jurisdiction point that is before the court.
And this is a very ancient edition. Is that for the purpose of showing us this is an old principle?
This is an old principle, an established principle. Yes, my lord, exactly. And this principle is one that carries right through under the Act as well. So what the court is dealing with is something that is very well established, recorded in Russell, and then carried through into modern cases that we'll look at momentarily. And I will pause just to explain the significance of this to the point which my Lord Justice Males articulated as the focus of the court today. If the Czech Republic is right on the severability issue, then what that militates, in my submission, strongly in favour of is either variation consistent with the Czech Republic's primary case or a set-aside of the affected paragraphs in the award consistent with the first alternative and option A of the second alternative in the Czech Republic's draft order. So I don't want it to be lost, at least in my sight, as to why these severability points are important for the court in determining those list of points that my Lord Justice Males set out a few minutes ago. If the Czech Republic is right on this, it militates in favour of those first three alternatives that are set out in our draft order. Now you can see here, beginning at the bottom of page 430, what the learned authors say about the situation of partial excess of jurisdiction. At the bottom of 430, an award bad in part may be good for the rest, statement of logic. We turn over to page 431, we see the point partial excess of jurisdiction a quarter of the way down. If the arbitrator has exceeded his authority as to part of the award only, and the bad part is clearly separable from the rest of the award and does not affect the good part may be allowed to stand. The mere presence of superfluous matter does not invalidate an award. So there's a need for it to be clearly separable under the established law. Where the bad part is separable, the next bit, the bad portion, however, must be clearly separable in its nature in order that the award may be good for the residue. When it is so divisible, the faulty direction will alone be set aside or treated as null. If we turn over the page, please, operator, to internal page 432, we see the last subsection is when bad part inseparable. If the objectionable provisions in the award are inseparable from the arrest, or not so clearly separable that it can be seen that the part of the award attempted to be supported is not at all affected by the faulty portion, the award would be altogether avoided. Now, I certainly hear the point, my lord, but this is an addition, I think, from the 1980s, predating the Act in 1996. But the reason that this is an important starting point is that when one looks through the authorities in relation to arbitration awards and separability, the test is a consistent metronomic presence. It often applies in the circumstances of costs, as the defendants agree and have made their submissions on, but it also applies in other contexts as well. And so in those circumstances, the proper lens through which this court should view the appropriate terms of its order as a consequence of its judgment is the lens of whether the bad parts of this award are inseparable from the good parts. If they are not, then those paragraphs where they are not separable ought to be varied or set aside together. When I come to the terms of the draft order the Czech Republic proposes, you'll see that this is not a large glut of paragraphs that we are dealing with. There are limited paragraphs in jurisdiction, we've already glanced at those. There are limited paragraphs in merits, and then there is the section on damages that the court has no doubt looked at. Now, I won't dwell on the cases where the partial excess of jurisdiction related to costs, because the parties are agreed that those cases exist, and that is where the doctrine of separability certainly does apply. But I do want to look at cases where this doctrine arose in analogous contexts in arbitration-related proceedings. The first of those is CVX, a decision of the Singapore Court of Appeal, with Lord Mance sitting as an international justice. This is at Authorities, Bundle 1, tab 30. Now here the issue did relate to the interrelationship between two different orders. So I accept it as a slightly different situation, but it's an important one by way of analogy. As one can see on page 2 at paragraph 3, there were two arbitrations under two share purchase agreements, heard together by the same tribunal, resulting in two phase 1 partial awards, two phase 2 partial awards, and then a final award which went to costs. If one then turns over to paragraph 8 on page 5, internal page 5, one can see the claimants applied to set aside the phase 2 partial award, for reasons set out there, and also the costs award. Singapore being a model law jurisdiction, one can see over the page in paragraph 10, Article 34 of the model law is quoted, which I'm sure will be familiar to the court. If one then turns to internal page 35, and looks at paragraph 63 to 64, one sees that the court accepts the tribunal exceeded its jurisdiction in making the phase 2 partial awards and sets them aside. Now the costs award cover the costs of both arbitrations. You can see that, my lords, my lady, at the top of paragraph 65. The defendants in those proceedings submitted the costs award could not be disturbed because there was not a separate ground for attacking it, or that if it could be, it was limited to parts of the decision that were inextricably linked to and flowed from the part set aside, contending that did not apply here because the cost award took into account a variety of considerations and not just the point upon which set aside had been ordered. If one turns over the page, one sees at paragraph 70 and onwards a number of authorities cited. These are the authorities which were also cited in the Czech Republic submission and were cited in Russell in the pages that we looked at a moment ago. And then at paragraph 71 to 72, the court reasoned as follows. The case where a whole award is in excess of jurisdiction stands at one end of the spectrum. In such a case, any cost award may indeed, in some circumstances, itself be in excess of jurisdiction. But even if it is not, it will inevitably or almost inevitably be inextricably linked with the invalid substantive award. The case of a whole award set aside for breach of natural justice comes next on the spectrum. Any cost award will normally have depended on the substantive award now set aside. Then comes the case of an award capable of being and actually set aside for error of law, which is subject to similar comment. The present case differs from all these cases because only part of the substantive award is in excess of jurisdiction and so set aside. And the cost order made took into account a range of considerations, including considerations relating to substantive aspects of the award not set aside, the conduct of the case, and the overall costs. The tribunal's conclusions regarding substantive aspects now set aside, the award for the remaining amounts independently of acceleration and the compound interest award, were clearly a significant matter in the tribunal's mind when it made its cost award, an award which is based in material part on illegitimate considerations is flawed and cannot, in fairness, stand. And then an important paragraph, my lords, my ladies, certainly one debated between the parties is as follows, at 73. In terms of the IAA and model law, we consider that this conclusion follows from first principle. The fruit falls with the tree. Where a later order is ancillary to and depends upon the validity and premises of a prior order, the legislature cannot have intended that the later order should survive the setting aside of the former. The next two sentences can be read to oneself before it is concluded. That would serve neither the cause of nor the sensitive supporting role which courts have towards arbitration. And if one turns the page, the last paragraph I will take the court to in this chunk is 74. Ultimately, the test whether a cost order can survive must therefore be one of materiality and judgment. There's a reference there to G.D. Medea, which is an important judgment that we'll come to in a moment. And that paragraph concludes. All these are phrases addressing the fundamental question whether one finding or part of an award is so related to or dependent on another finding or part of the award that the former cannot continue to stand once the latter is set aside. The phrases referred to in that final sentence are phrases used by the court in G.D. Medea to explain circumstances where good and bad parts of an award are bundled up together, are linked in a way that means they are inseparable and therefore they must fall together. Looking quickly at G.D. Medea, decision of the High Court of Singapore. That's in Authorities Bundle 1, tab 27. Now, as one can see in paragraph 2, which is on internal page 1, this was an application by Medea to set aside the award in part, an application by Medea to set aside the enforcement order in favour of the defendant. The court can see the challenges that Medea advanced at paragraphs 33 to 35, which are at internal page 9 through to 12. There are quite a number of challenges I don't propose to dwell on. Now, Justice Chua Lee Ming's findings can be picked up at paragraph 62, which begins on internal page 20. Now, the court there found that a particular finding, what was referred to as the clause 4.2 finding, was in excess of jurisdiction and a breach of natural justice causing prejudice to the claimant. There's a series of paragraphs where the judge reasons through the effect of that before we pick it up at paragraph 72 on internal page 24. As one can see in those paragraphs, the court accepted that other findings were also tainted by the fact that clause 4.2 finding was in excess of jurisdiction. And this is the passage, my lords, my lady, where Justice Chua Lee Ming uses those phrases that Lord Mance referred to in CBX. This is where the judge refers to the good and bad parts of the award being inextricably linked, clearly linked, or an important part of the findings, and so on. Indeed, that is set out at paragraph 73 to 75 over the page. Glancing through those, one can see the judge's explanation of the type of linkage that is leading the judge to say the good part of the award must fall with the bad part. Those parts of the award, including merits parts, I emphasise, must fall because the clause 4.2 finding was outside the jurisdiction of the tribunal. Paragraph 76 is where the judge identified one finding that was not linked in this way and therefore was a good part of the award that did not fall with the bad part. So the wording used by the judge in that case reflected the degree of connection the judge saw between the good and the bad parts. In my submission, the passage in Russell reflects the English test, and the language used there that we saw is a correct explanation of the type of inseparability that is required. Indeed, Russell is clear that the burden is on the defendants to show that the two are clearly separable, which in my submission is a low bar. Just for completeness, if the court wishes to see the end of Justice Chua Lee Ming's findings at paragraph 77, the court decided to set aside rather than remit the matter. So there, a court exercising the supervisory jurisdiction that we were discussing at the outset of my submission this morning. As one can see, my lords, my lady, I'm coming up from what my Lord Justice Mayers referred, I think, to an ancient version of Russell through to modern times with these decisions to see the way in which those principles in Russell have developed and been applied in relevant cases considering the separability point. The next decision I wish to take the court to is William Hare. It's in the same authorities bundle behind tab 26. This is a decision by His Honour Justice Dark of the New South Wales Supreme Court. It was appealed but is upheld. The appeal decision is not in the bundle as a result. So behind tab 26, one can see in the first paragraph of the judgment, turning to page 3, that the claimant sought to enforce an award made in the UAE. So I accept this as an enforcement proceeding, not a set-aside, but the analogy and the use of separability as a principle, I say, is persuasive as to how the court should approach the task before it in this case. Paragraph 8, my lords, my ladies, on internal page 5, and that says the award consisted of an entitlement to 2 payments from the defendant. Now, the defendant challenged enforcement, focusing on circumstances in which the second payment was ordered to be made as a breach of natural justice. And one can pick that up at paragraph 11 over the page. Now, I don't need the courts to look at it closely, but the court upheld one contention but rejected the other. That's at paragraph 63 and 104 of the award, of the judgment. If one now goes to paragraph 105 to 106 of this judgment, which are at internal page 44, so it may be helpful if you're looking in hard copy just to glance at the bottom of 43, so one can see that's where the judge is discussing severance of award. So very much on point for what the Czech Republic says this court is ought to be considering. One can see at 105 to 106 The defendant contended that the award as a whole should be taken to be contrary to public policy and enforcement refused. The claimant, for its part, contended that the award affected by the breach was severable, and so partial enforcement was available. Now, the following 10 paragraphs or so by His Honour Justice Dark cover authorities which discuss this point from a range of jurisdictions. I won't pause on those now, but if one turns forward a couple of pages, one sees that review of authorities coming to an end at paragraph 117, where the judge is discussing the well-known IPCO case of the English Court of Appeal. So based on a proper review of authorities, His Honour reached his reasoning from paragraphs 118 onwards. At 118 and 119, His Honour notes that the legislative language was similar between the various jurisdictions that he had looked at, not surprising given that they are all New York Convention jurisdictions. And then if I can pick up his reasoning, please, at paragraph 124, which is in internal page 54. There, His Honour accepted that some awards might be affected by natural justice problems, but only affecting an identifiable part of the award. But they equally may be more pervasive and cover other parts of the award as well. And the way in which the judge said a court ought to distinguish between these situations was through the doctrine of severance. At 125, having set out that reasoning in 124, His Honour held the principles of severance have been applied to arbitral awards for centuries. Those principles have been applied in the context of international commercial arbitration. Those principles are themselves firmly based upon notions of justice. Now, the last case that I want to take the court to briefly is the case of Chamria. Now, I believe the court has a supplemental bundle of authorities that may have been delivered as late as yesterday.
I don't think I do.
No, not me.
Well, I apologise if you do not have copies, but the case that I am taking the court to is a case of Chamria, which is a Privy Council decision, admittedly again somewhat old, from 1925. I'll just pick up a...
Are you proposing to give us copies, or do you want us to follow it on the screen?
We can hand up hard copies, certainly, my lords, if that's simply the easiest way to do it. It is on the screen. I'm grateful to the operator for finding it, but while we source hard copies, we might work through what's on the screen. Now, if we can zoom in perhaps a little bit, operator, and if we go over to page 2, we see that it is an appeal from an order which set aside an arbitral award. You can see that in the first 2 paragraphs of main text. If we can go to page 6, please, operator. I'm grateful that we have copies, hard copies for the court just coming in. If we go to page 6, in the middle paragraph, I don't know if we can zoom out a little bit now that we have hard copies being circulated. The reference to arbitration had been made by court order, and it was in a family dispute that was before the courts. One family member, by the name of Anadai, was not party to the court proceedings, and various disputes were not in issue in those proceedings. So it's quite important to process before going on to read the reasoning in this judgment, that there were different parties to the court and arbitration proceedings, and some issues were live in the court proceedings that were not part of the reference back to the tribunal by the court. If we go over to page 7 now, please, operator. The large chunk in the second half of the page makes it clear that the court only had power to refer to arbitration questions between the parties to the proceedings before it. Unsurprising, of course. If we come over now to page 8, we start to see the board's reasoning. in the second half of the page, the court will pick up that the arbitrators did not wait for the court's formal order before it published an award which dealt with matters going beyond those that were in issue in the court proceedings. So a fairly clear example in the board's opinion of the tribunal going beyond what had been referred to it, this time referred to it by a court rather than the parties. If we pick up the paragraph at the bottom of page 8, one sees their lordships' reasoning. It is clear to their lordships from the terms of the award itself, and there is extrinsic evidence to the same effect, that in reaching their conclusions, the arbitrators took a comprehensive view of the family situation and made an award which doubtless they regarded as just on the whole and as a whole, but which probably they would not, in any of its parts, have themselves made precisely in the same terms, if the dispute thereby dealt with had alone or separately been submitted to them for adjudication. If we go over the page to page 9 and scroll down towards the bottom, the paragraph beginning towards the bottom, in their lordship's judgment, such an award is in no true sense one made in obedience to the order of May 23, 1922. That's the court order referring back to the tribunal. While it would not be easy to segregate the findings with reference to the matters in question in the suit from those not so in question, the findings in which Anna Dai was interested from those in which she was not, it is, their lordships think, impossible to uphold an award in relation to a suit, the conclusions of which were plainly coloured, if not dictated, by the view taken by the arbitrators of other questions between the parties, or some of them to which the suit had no reference. Just so the court can see the conclusion on page 11, over the page, please, operator, the court approved the order setting aside the award, and that was even in relation to matters which were within the proceedings which had been properly referred. So, good part of the award set aside with the bad part. So what one sees there is an example of an award set aside because there was a non-party dealt with in the award and claims beyond the proper scope of the reference dealt with by the tribunal. But the focus is on whether the analysis of what was within jurisdiction and what was not can be disentangled. In this case, Sharia, it could not be disentangled. So even that part of the award relating to parties that the tribunal did not have jurisdiction over fell away. Pardon me, did have jurisdiction, I apologise. So I'll start that sentence again. So even the part of the award relating to parties that the tribunal did have jurisdiction over had to fall away. The good with the bad. That is the review of cases on separability. I explained, my lords, my lady, why that is relevant to the list of key considerations that the court has, as my Lord Justice Mayall set out. If the Czech Republic is right on separability, that militates strongly in favour of one of the first three alternatives in its draft order. This is consistent with the language in the Act that I touched on briefly. It's consistent with the long case law that we have seen, and it's consistent across different types of applications before courts in relation to arbitral award. Now I'm going to come to the draft order the Czech Republic proposes in a moment and walk through that in order to address the points that my Lord Justice Mayall articulated as the focus of the court. But before I do leave separability, I wish to make just one further point. You'll have seen that the defendants, to the extent they propose any separability, do so on a party-based approach, i.e. they say that the award has no effect in relation to Diag Human, but just stands in relation to Mr. Stava. Now, the Czech Republic's approach to severance, which based on the case law we have seen, focuses on claims and issues rather than just individual parties, functions perfectly well in a multi-party case where the defendants have decided to bring their claims together in a single arbitration which has resulted in a single award, such as this case. In contrast, in my submission, a party-based approach to severance, as the defendants contend, has undesirable outcomes. In particular, if the defendants' approach were to be adopted, the tribunal's decision whether or not to bifurcate jurisdiction may both affect the availability of court review and create inconsistency. let me just unpack that a little bit. If the tribunal did bifurcate jurisdiction and adopted this court's correct analysis of the ownership and control point, its subsequent merits analysis in relation to Mr. Stava's position would then have to be consistent with that. One would expect it just to flow downstream. But in contrast, if the tribunal dealt with the points in an award, dealing with jurisdiction and merits together, as they did here, then the analysis is wrong. But my learned friend's party-based approach to severability would nevertheless immunise the position in relation to Mr. Stava from review. Had there been bifurcation, the court would have made, the tribunal would have made its determination on jurisdiction. It would have had the correct approach to control and ownership as supplied by this court. And then it would have gone on to merits and it would have flowed from there.
And it could it, have made all the findings it wished to make vis-a-vis Diag, albeit that it couldn't make an award against Diag.
The tribunal could certainly make findings in relation to a third party as a matter of fact, relevant to its reasoning.
On this hypothesis, it having no jurisdiction over Diag would be such a third party.
Third party findings are obviously perfectly common in arbitration, but what the tribunal cannot do in relation to findings concerning a third party or a party before it is make findings on the merits that are jurisdictionally unavailable to it. If a tribunal only has jurisdiction to make findings, for example, after a period of time, then it cannot, as a matter of merits, say that there has been a breach before that period of time, which leads to damages.
Aren't we confusing jurisdiction to make an award against somebody with jurisdiction to make findings of fact?
Exactly.
And so, as I say, a finding of fact is entirely possible, but what one cannot...
How is, I'm sorry to interrupt you, but how is a premise, which is the premise we're on, which is that there is no jurisdiction to make an award against Diag, how does that inhibit the tribunal in its jurisdiction to make whatever findings of fact it feels necessary in relation to Diag, necessary for the purposes of determining the claim in favour of Mr. Starr?
So findings of fact, my lord, is not the point that the tribunal would not be jurisdictionally competent to do. It can make a finding of fact that is relevant for whatever purpose it likes. But the point that I am drawing out is that whatever findings it makes, it cannot then go on and make a determination of merit, so a determination of breach and award of damages, if that determination on the merits falls outside jurisdiction. So if I can develop my example from a few moments ago a little bit more. If a tribunal holds that it has jurisdiction over a 20-year period, and there are some breaches in the first 10 years and some breaches in the second, but then it is corrected and said, no, you only have jurisdiction over the second 10-year period, then that tribunal, on remission, may still wish to make findings of fact relevant to the first 10-year period, but it cannot say that there is a breach during that first 10-year period which leads to damages. And the reason for that is that its jurisdiction is limited to finding breaches in relation to the second-year period.
No, its jurisdiction is limited to awarding damages by reference to breaches in the period in respect of which it has jurisdiction, not to making findings about breaches in another period.
My lord, I'm perfectly happy to adopt that formulation, because that formulation is, in my respectful submission, crystallising the point, but making the same point that I have just made, which is that it is not possible for findings that are giving effect to or are an expression of jurisdiction that the tribunal does not have to be made by that tribunal. It may well be that we are saying the same thing in different terms, but I gratefully adopt what has fallen from your lordship in that regard. Now, the reason why I've been developing this point in relation to separability is because, as I've said, if the Czech Republic is right, that militates in favour of the first three alternatives in our draft order. But also because it removes the possibility, which is inherent in what the defendants are arguing, that a procedural decision by a tribunal can lead to different substantive outcomes. Now, as I said a moment ago, if there were to be a bifurcation in this case, jurisdiction was decided, it came before the court said no, jurisdiction was incorrect in relation to Diag Human, so it drops out. It would then go back to the tribunal to make its, for the subsequent phases after jurisdiction, which would then be determined. But here, what the consequences of the defendant's position is that by making one unitary award, the tribunal is in effect immunised from any real challenge to one party of the consequences of the other party dropping out. So here, my learned friend says that Diag Human drops out, and that's as simple as that. The award stands unaffected in relation to Mr. Stava. But had there been a bifurcation in this case, the parties would then go back before the tribunal after the supervisory court had made its determination on jurisdiction. And there would be no unitary award. The only breaches and damages that flow therefrom that could be determined would be solely those in relation to the remaining claimant, here, Mr. Stava. So it's quite an important point I respectfully submit, that a procedural determination like that ought not to guide a substantive point. My lords, my lady, I turn to the draft order now. The Czech Republic's revised draft order is at paragraph 20 of the hearing bundle.
Could you just help me with this? Why does the question of control after 2011 logically affect Mr. Stava's damages claim as a matter of merit? If the tribunal have found, just take that as an if for the moment, to look at the principle, you may say this isn't what the tribunal has found. But if the tribunal had found, let's put it that way, that Mr. Stava was an investor, he had suffered loss by 2008 to himself, not Diag's loss. He'd suffered loss, and that might be, one might hypothesise, because of the diminution in the value of his shareholding, and that is quantified in the amount of the 2008 award. If he gives away his shares in 2011, he still suffered that loss. He's just given away shares that were worth less as a result of the Republic's breach of its treaty obligations. Why does that diminish his loss?
2 points on this, my lord. The first is that in circumstances where it is the company only, not Mr. Stava, that is party to the 2008 Commercial Arbitration Award, and so that is the asset that it has. The fact that Mr. Stava has given away his shares in the company means that it would run entirely contrary to that for Mr. Stava to then have a BIT claim in relation to the impact on Diag Human. In circumstances where the 2008 award stands as the sole basis of quantification in the award, and it's only in respect of Diag Human as a party, in our submission, the alienation of the shares is terminal to his ability to claim in that connection. The second point, my lord, is that in any event, as is not disputed between the parties, Mr. Stava did not own 100% of the shares at the time of the breach underlying the 2008 commercial arbitration.
That's not a point you've ever raised before. Certainly not before this court.
I accept, my lady, that it was not raised in the appeal, but in the substance of the appeal. but as a consequence of the finding on the third appeal, where the court is considering whether or not to remit a matter back to the tribunal. Once it goes back to the tribunal.
But was that a point that was taken before the tribunal?
Yes, yes, strongly. And indeed, even the arbitral claimant's quantum expert said outright in his report that there may need to be reductions if the claimants did not have, claimants plural, but really meaning Mr. Stava, did not have the full entitlement to 100% of the loss that was being claimed.
And the tribunal must implicitly at least have rejected that in making an award in favour of Mr. Stava.
Well, whether it implicitly rejected it or the line of reasoning in the damages part of the award based on the recognition under international law of the 2008 award meant that it had simply gone down a different line of reasoning, I think it would be a debate to be had.
But in either event, would that have been a matter that you ought to have challenged by Section 68 or Section 69 application?
So, my lord, that is a point that the Czech Republic challenged, and it is one which was, if I can put it this way, a contingent challenge. I'm just having the relevant paragraphs of Mr. Justice Foxton's judgment pulled up to reflect this, but it was a contingent challenge depending on the outcome of the appeal. I'm grateful to...
Was it rejected by Mr. Justice Foxton?
Sorry, this is in the March judgment, my lords, my lady, at paragraph 228 in particular. Now, I don't know if the operator can get up CB/12/77. So, if I can put it in summary terms, this is where His Lordship is considering the position of the Czech Republic, the challenge the Czech Republic brought in relation to, if I can summarise as not 100% point. So His Lordship at 228 addresses a point in his March judgment. And then if we carry that through to the August judgment, which operated at CB/23/84, one picks that up as...
Give me that reference again.
Pardon me, it's CB/23/84. Now, I'm afraid, my lord, that I'm working from the core bundle from the original hearing.
So am I.
Oh, I'm grateful. And one picks it up at paragraph 263 to 264, which His Lordship calls the outstanding Section 68 issue. And if the court then reads on to 264, you'll understand why I refer to it as a contingent challenge, because it depends on the outcome of the appeal. So the point has been challenged, and just in relation to my lady...
Sorry, okay, you're going a bit too fast for me. The contingency at 264 is that Mr. Stava's jurisdiction challenge in relation to Mr. Stava might succeed. Is that right?
Well, with respect, my lord, I think when it says that the appeal against the March judgment succeeds, or other appeals are brought and succeed, so I'm not sure it could be limited to just one claimant.
But the contingency is whether Mr. Stava has the ability to bring a claim in respect of the 2014 review.
Yes.
Where do we find the part of the order that deals with this? The August order.
Pick that up.
It's tab 22, but which paragraph?
Bundle/22.
While we're going there, this is a contingency as to jurisdiction, subsequent jurisdictions findings in relation to Mr. Stava's claim.
Essentially, in the sense that if there are appeals brought before this court, and those appeals have some sort of consequence on the non-100% issue, if I can summarise it as that.
Isn't it saying it's dependent upon this court saying that Mr. Starver did not have an ability to bring a claim in respect of the 2014 review breach. Isn't that what it's saying?
In the second sentence of 264, it does refer to that.
It's the last sentence as well.
But also, well, the next sentence,
Getting that.
I will take a moment to consider, my lord, my lady, and maybe come back to that point. But the reason why I raised this point was in relation to my Lady Justice Andrews' question as to whether this had been raised before. Before this court, it was not raised in the context of the appeal hearing that has led to the court's judgment. However, as a consequence of the determination of the third appeal in relation to control, the matter is remitted back to the tribunal. And my learned friends say, well, there was always a possibility to claim before the 2011 alienation of the assets for any breaches that Mr. Starver might be able to claim in relation to. Then there's the first point I made about how his alienation of those assets means that he isn't able to claim. But the second point is that there would need to be reconsideration of what loss would flow from any pre-2011 breach that affects Mr. Starver. If there is to be any debate about that, then the Czech Republic would certainly say that serious injustice would arise in those circumstances where it is not able to say that there is a limitation to either 53% being the percentage he held at the time, or 0% being the percentage that Czech Republic says is correct, flowing from those arguments.
How do you say that flows from the fact that there's no jurisdiction against Diag?
Sorry, pardon me, my lady.
Why do you say that that flows in any way from the fact that there's no jurisdiction against Diag?
So, my lady, we say it flows from the fact there's no jurisdiction against Diag, because a consequence of that is that Mr. Starver, having alienated the shares in Diag into the trust, is not able to bring a claim for those shares that he has now alienated away. We say that affects not only the post-2011 breaches, but also the pre-2011 breaches for the reasons set out in our submissions. Now, the defendants say, at a minimum, the pre-2011 breaches are unaffected in relation to Mr. Starver, and he's still able to claim in relation to the Boyar letter breach. Our position in relation to that is that, no, he cannot, but in the alternative, if that is to be live again before the tribunal, it cannot be on the basis that he has a 100% interest in the company at the time of the Boyar letter breach. It's not disputed that he did not have a 100% interest. So as a consequence of this court's finding in relation to Diag Human, it flows through in that way to affect Mr. Starver in relation to my learned friend's arguments for the pre-2011 breaches.
But might it just be put this way, that the tribunal found that he was entitled to a claim as to the total amount of Diag's loss. You challenged that under Section 68. The judge rejected that challenge, subject initially to a contingency that it would depend upon whether the jurisdictional challenge vis-à-vis Mr. Starver succeeded. The jurisdictional challenge failed, the contingency fell away, and therefore we are bound to treat the award as not open to challenge on a factual basis that he didn't have 100% shareholding.
So, my lord, as I say, that's where we would say a serious injustice would arise if that was where the ultimate falling of the matter was. But in terms of what is to go back before the tribunal, in my respectful submission, it wouldn't be correct to say that because of the nature of the Section 68 in relation to the BIT award, damages ought to be calculated on an incorrect basis flowing from the remission back to the tribunal. So even if there is a limitation on what the Czech Republic can say was challenged under Section 68 in relation to the previous BIT award, upon the calculation of damages flowing from, and as a consequence of this court's finding on the third appeal, that's where we say that it couldn't be calculated at a minimum as being a 100% entitlement.
But if you would not, I'm sorry to interrupt you,
If you don't mind, if I just finish, I only had one more sentence in the thoughts. In circumstances where the tribunal's findings on damages had been limited to, exclusively limited to, a recognition of the 2008 award, and we say that finding falls away, the tribunal will have to come back again to reconsider the position on damages, and that's where we say, at a minimum, the tribunal could not sit there and say, I can no longer use head of damages 1 to recognise the 2008 award. I have to use head of damages 3 to calculate the loss from scratch, so to speak. And in that recalculation of the loss from scratch under head of damages 3, it simply would not be factually correct to say that Mr. Stava has 100% of the damage. He didn't, and that's not disputed. I'm sorry, my lord.
No, I'm interrupting you too much, and I know we're short of time, so I won't pursue.
I'm grateful, my lord. I think the court was just starting to pull up the revised draft order of the Czech Republic, which is in tab 20 of the hearing bundle.
I don't think it is. I think it's in tab 8.
That was the original draft order, my lord, which was prior to the remittal award being handed down, prior to setting the court's query of the 23rd of May and so on. Do you have a copy behind tab 20?
The index says the Czech Republic's revised draft order, tab 20. But the document behind tab 20 is some submissions of Diag Human and Joseph Stava. At least in my copy.
Sorry, my lord, not very helpful. It is on the screen, my lord.
I do have a draft order there, but it was only added to my bundle this morning. So.
Oh, I wonder if I have it somewhere here. These look like all authorities.
We have a spare hard copy, my lord, if that will assist.
Thank you.
Does my lady have a copy?
No, I'll wait.
Thank you very much.
Thank you.
Now, just turning through the provisions of the draft, I'll start briefly with the recitals. The Czech Republic has proposed that the recitals record the undertakings that were given by the parties to the court pursuant to Mr. Justice Foxton's request. That's as I referred to order earlier. And also that the recitals record, when stating that this court has handed down judgment, where the cumulative findings regarding Mr. Stava's ownership and control that result from the proceedings before the court can be found. Basically just a reference to Annex 1. It's a small point in the recitals, my lords, my lady, but I'm just explaining the difference there. Paragraphs 1 to 3, these are the results of the 3 appeals. They're identical, I think, with the defendant's order, except that we say in paragraph 3, when recording the result of the 3rd appeal, there should also be a provision declaring that the tribunal does not have jurisdiction in respect of any claims of Diag Human. I don't understand that to be contested, but it has not been picked up in my learned friend's draft. Natural consequence of the judgment we saw. So paragraph 4 is the key substantive provision in the order. It works by amending paragraph 1 of the judge's order of 25 October last year, which he made following the completion of the trial. Now, at a high level, the approach is common to both sides, though obviously what needs to be amended in Mr. Justice Foxton's order is not common. We have proposed different iterations depending on which approach the court wishes to adopt. There is a common core to our various alternatives, which is that the court exercises that supervisory jurisdiction I was referring to before, and then if there is no variation, the tribunal carries on based on the remission before it. So our primary case is as set out in paragraph 4 on page 4. And this is where the court can vary the award directly, including the damages to which Mr. Stava has entitled. For the reasons I've given, we say that there is no arguable case he is entitled to recover damages given that he parted with the shares of Diag Human. Now, if that is not accepted by the court, the Czech Republic's first alternative is over the page at page 5. And that alternative is to vary paragraphs relating to the jurisdictional findings, which we glanced at briefly this morning, and set aside other paragraphs of the award. There is then what's called the second alternative, a little bit down page 5, which is the court positively making a remission to the tribunal. This is picking up the court's query by email on the 23rd of May. The Czech Republic has set out two possibilities here. The first, at option A, is that the court again sets aside some paragraphs but makes a positive remission.
So you're going a little bit too fast for me. Option A is essentially to set aside the dispositive parts of the award and positively to remit what award, if any, should be made in favour of Mr. Stava in the light of our judgment and reasons. Have I understood?
Essentially, yes, but the formulation of the remission is there in the middle of the page, the indented paragraph F. And so you can see there, the reason I just focus on that formulation is that there are slight differences between that formulation and the formulation in option B, but we have sought to capture the language of the court from its email of 23 May as much as possible. Option B, which begins at the bottom of the page and carries over, is the option where the court simply remits to the tribunal at large, if I can put it that way, the question of what changes, if any, to make to Mr. Stava's entitlement. So one can see the explanatory note under the heading of option B, which I'll just pause for the court to review.
Sure myself what the difference is. Does option B not allow the tribunal to make a different award in favour of Mr. Stava?
It does allow that, my lord, but there are two slight differences just to draw attention to in indented paragraph F on page 6. The first of those is that it captures the remittal award because that has now obviously been issued and so should be scooped up in our submission in this order. There is a second slight difference from what the defendants say, at least, which I might come back to as I work through the document, but it is a slightly different form of remission, my lord. Option A still sets aside various paragraphs of the award that the tribunal has issued, as well as the dispositive paragraphs, whereas option B simply has a remission at large.
I see.
So functionally, there are similarities between the first alternative and option A and option B in the sense that it would go back to the tribunal, but the differences between those three options focus on whether or not the court will set aside paragraphs in the award, which in my submission, as I've explained, it ought to do as part of its supervisory jurisdiction. It's appropriate for this court to do that set aside. That's not a matter which falls to the tribunal to do in our submission. Now, can I just come back to the main paragraph 4, which is on page 4. And just pick up at paragraph A. This is the paragraph where we say the award ought to be varied in relation to jurisdiction and replacing those findings on jurisdiction with the findings set out at Annex 1 in the order, which is on page 7. The function of that is to remove the tribunal's erroneous findings, which led it to uphold jurisdiction in relation to Diag Human, and replace it with the correct findings. The defendants oppose this, as the court will have seen. Paragraph B is indeed common ground. That's the paragraph in the award at 395, which is to be deleted and varied. paragraph 395, it's common ground that needs to be deleted. But then paragraph 413, we say is to be varied in some respects. But there is a dispute between the parties as to exactly how that variation should be. We say it should again refer to the reasons why the objection regarding Diag Human was upheld. My learned friends say simply that the objection is upheld. So a slightly more level of detail in our formulation in paragraph B there. Paragraph C is the changes to the dispositif that flow through. As the court will have seen from looking at the alternatives focus on this paragraph as the one that would be amended depending which alternative is chosen. And then paragraph 4D is where the Czech Republic says that other provisions of the award need to be varied or set aside or declared of no effect. And that is in Annex 2 is where those findings are set out. If we could turn to Annex 2 now, please. Operator, that's on page 8.
So your version simply deletes any reference to undertakings.
So, my lord, it is actually the defendant's version that has deleted the reference to the undertakings. On our primary case, we say, of course, that the award needs to be amended so the entire damages part is removed. So in those circumstances, the undertaking provision is not required. But if it is to be remitted, then there are variations of that go through. But that undertakings point, if I can just pause on it before coming back to Annex 2, as my Lord Justice Mowes indicated this morning, is an important point. Because as things stand, the defendant's proposed order removes the undertakings that have been given by Diag Human and Joseph Stava not to enforce the 2008 award. That's the amendment to the dispositif there. And the reason why that is significant is that I assume the defendants will say that Diag Human can still go away and enforce the 2008 award. Indeed, there are proceedings that are currently suspended in Luxembourg where it is seeking to do so. And on my learned friend's case, Mr. Stava has the entitlement under the BIT award, the 2022 award, which he can then go away and enforce. So while we do not accept that either of those are enforceable awards, that seems to be the contrivance, if I can put it that way, that the defendants are seeking to achieve, whereby there is actually, on one view, an improvement in the position of the defendants. That is a position which, in my submission, the court ought to be very wary of endorsing. That's not an approach which, in my submission, ought to be properly recorded in a consequentials order where the Czech Republic has succeeded on the third appeal and Diag Human is dropping out. So in those circumstances, we submit that there is factors militating in favour of the Czech Republic's approach of variation or set aside, and if it is set aside, the tribunal carrying on from there. Now, authorities were added to the bundle yesterday afternoon, I think it was, from my learned friends dealing with undertakings. Not heard what they have to say on that. It may well be that a submission is made that Diag Human is still bound by the undertaking given to the tribunal, or given consequent on the tribunal's dispositif. But if that is said, I will reply to it this afternoon. But in short, we do not accept that that would be an effective and reliable version of the undertaking. Indeed, it's not at all clear to us how, if Diag Human is dropped out of these arbitration proceedings and there's no jurisdiction over the tribunal to order Diag Human to do anything, how reliable that undertaking would be. So in those circumstances, my lord, we'll hear what my learned friends say after lunch, but the undertaking point is one that, in my submission, ought to cause real trouble to this court, endorsing the approach that my learned friends urge upon it.
Well, it may be that it could be, as it were, sidestepped by Diag simply giving an undertaking in the same terms to this court, which, as they are before the court, they would be in a position to do.
I'm happy to hear what my learned friends say in that regard, but if Diag were to give an undertaking not to enforce the 2008 award and was also not to be able to enforce the BIT award because they are not properly within the jurisdiction of the tribunal, that would still militate in favour of variation or remission, because then the lead question will be, what entitlement does Mr. Stava have? If Diag Human has given that undertaking, the natural next and largest question is Mr. Stava entitled to the same amount of damages that Diag Human was entitled to under the 2008
Well, that's a
award?
slightly different. There are various possibilities as to what does and doesn't go back. If we're looking at just the double recoverability point on its own, on the hypothesis that the damages claim as a whole doesn't go back, then what my lord suggests might be a way of dealing with that problem. Whereas, speaking for myself, I do see that whatever you do with treating the approach to the tribunals, the approach the tribunal took to the damages claim, they clearly had in mind that the damages award in favour of Stava should be on the basis that there was no possibility of double recovery and that it required the undertakings, and you make your points about what's necessary to make those effective.
Indeed, and the relevance and materiality, to take the language from the case law, of that consideration to the tribunal's damages reasoning was high. And given that it was high, that does favour either variation of the award to remove the damages altogether and say the entitlement is nil, or if the court is not with me on that, a remission back to the tribunal so that head of damages 1 is no longer possible for the tribunal to use, as it did exclusively, and head of damages 3 therefore needs to be considered by the tribunal in those circumstances. Czech Republic's position is still going to be that the entitlement is nil, but my learned friends will no doubt say that the entitlement is higher than that. But all of these factors arising from the existence of the undertakings, and frankly, whatever permutation my learned friends say about those undertakings moving forward, all point in the direction of one of the first 3 alternatives in the Czech Republic's draft order.
Or it could just be remitted for the purposes of the tribunal deciding the narrow point as to whether the award should be in favour of Mr. Starr, should be amended to take account of the fact that the undertaking which was given by Diag was given to a tribunal which had no jurisdiction.
And if that is the ultimate decision of the court, that would be reflected in option B of the Czech Republic's draft order. And the importance there is that while there is a remission back to the tribunal without a formal set aside of the paragraphs of the award, that remission would still be on the basis, I'd respectfully submit and request, that the tribunal have explained to it that its findings need to proceed from the findings of this court as reflected in Annex 1 of the order.
What I was suggesting was something rather narrower than option B, which makes clear that the scope of remission is only to deal with the double recoverability aspect, not to consider anew. I mean, I have your submissions on why that shouldn't be the result. All I'm just pointing out is I'm not what I was suggesting is not the same as your option B.
Well, that narrowness, if I may engage with it for a moment, my lord, in my submission would be quite problematic, because in those circumstances, what is being remitted to the tribunal is simply the narrow point about double recovery, but would effectively exclude the tribunal's consideration of any other effects of this court's determination that Diag Human is no longer party or proper within the jurisdiction of the tribunal. And for the reasons that I've given, there are quite a number of those issues which it must be at least arguable the Czech Republic would be able to persuade the tribunal it is correct on. And for those not to be remitted, even though they are natural and clear consequences of this court's finding in the third appeal, in my respectful submission, would not be the correct way forward. My lords, my lady, if we can just look at Annex 2 of the draft order, you can see that there are 2 collections of paragraphs. The first under the first grey line, which is various merits findings that cannot stand, given Mr. Stava's disposition of Diag Human in 2011. This relates to the findings regarding interference in the commercial arbitration after that date, and in particular, the tribunal's finding that the 2014 resolution was a breach of international law and not to be recognised, with the result that the 2008 award was to be recognised in international law. You can see them there, paragraphs 754 through to 831. The second collection of points in this first part of the page are various points where the tribunal said, in light of having made such findings that it had made, it did not need to decide other claims for reasons of procedural efficiency. We accept that. If we are setting aside the determination of other claims, we should also set aside these paragraphs there. Under the second grey line, these are the paragraphs where the tribunal analysed quantum, costs and interest. And you see there the Czech Republic is saying that these should either be varied to say that Mr. Stava receives nil, or in the alternative that they be set aside. So those are the key paragraphs in the order, in the award that we suggest would be affected by the order. Can I come just back briefly to the first and second alternatives of the order? So this is picking up at page 5 of the document. The first alternative is at the top of the page. If the court is not with me that it can vary damages to 0 for Mr. Stava, then the Czech Republic's position is that the appropriate approach is to set aside the affected paragraphs, which, consistent with Hussman, which the court will know, we accept before this court for this purpose, does have the effect that they could be taken up again in the arbitration by Mr. Stava. Now, we still say that even in this first alternative, the jurisdiction findings should be varied. So paragraphs 4A and B of the main order stay the same. The court would still be varying the award to put in the court's findings regarding Mr. Stava's ownership and control of Diag Human. Those are the findings in Annex 1. The difference in this first alternative is in the dispositif. It is varying the first limb of the dispositif to reflect the lack of jurisdiction regarding Diag Human. It then keeps the limb which finds a breach of Article 4.2 of the treaty, but simply sets aside the remaining paragraphs regarding damages, interests, and costs. That you can see is reflected in Annex 2. One would still make the same changes under the first grey heading, because those relate to the merits. But for the second grey heading, where you're dealing with quantum, interest and costs, that would be a setting aside rather than a variation to say no damages. So core difference between the primary case and the first alternative. The second alternative position or order that the Czech Republic has laid out on page 5 is that there is positively a remission by the court. So instead of relying on Hussman simply for the arbitration to resume under the first alternative, the second alternative involves the court making an order of remission. Here, the Czech Republic has proposed that that should be against the background of the court having already decided the affected paragraphs. So already identified in the award, these are the affected paragraphs. And that's as I have just explained by reference to Annex 2. So we can see that, first of all, that option A, which is very similar to the first alternative, but with the new paragraph F added in relation to remission. Now, there's a difference between the parties as to the appropriate wording. If there is to be specific remission, I'll touch on the defendant's wording shortly. Option B, as we've discussed, my lord, is a remission where the terms of the remission are that the tribunal decides for itself whether the award needs to be changed. There is a difference between the wording of the remission in paragraph F for the reasons that I've touched on. There is a small point which my Lord Justice Mayles touched on before, which I can take off the court's desk, I suspect. My learned friends have said that there should be a stay of the arbitration pending determination of any permission to appeal or, if granted, appeal. They say that the arbitration should not move forward until that is resolved. This was not dealt with in the Czech Republic's draft order, but I can confirm that the Czech Republic does not object to the defendant's proposed way forward on this stay, save for the fact that there is no reason to delay or stay the reconstitution of the tribunal. Given the resignation of the tribunal over the weekend, new arbitrators would need to be appointed. That is a process that takes a number of months under the applicable rules in this arbitration. That can carry on while PTA and any appeal is being determined. So a slight difference between the Czech Republic's position and my learned friend's position. Can we please turn to the award? And it's worth having the Czech Republic's draft order in hand at the same time. So if you have a hard copy of that out, it would be useful to keep it out. And as reflected in Annex 2 of the draft order, there are three buckets of points in the award to deal with. Can we start with the jurisdiction points that we glanced at this morning, beginning at paragraph 395? This is in relation to jurisdictional objection number 5 about whether the claimants are investors. You'll see from paragraph 395 up to 412 the tribunal recalls some of the submissions by the parties and sets out its understanding of its jurisdiction. These are the paragraphs that we say cannot stand due to this court's findings in its judgment. The court is no doubt familiar with those, but can read through it in your notional spare time. But if we just move forward to paragraph 408 on internal page 125, you'll see there that the tribunal has said, consequently, by controlling the Corona Trust, Mr. Stava retained the right to vote Diag Human shares and to collect dividends, even following the law book transaction, at least until payment of the purchase price. So in my respectful submission, that is clearly at odds with the position as now flows from this court's judgment on the third appeal. Similarly, if one looks at paragraph 410, Mr. Stava retained control over Diag Human even after the law book transaction. And then similarly at 411 and 412, over the page, we see the tribunal making similar findings about halfway down 411. The underlying transactions appear to align with Mr. Stava's testimony that at that time Diag Human was pursuing settlement discussions in the Czech Republic and Mr. Stava had been advised to publicly distance himself from the company. That was in contradiction to what the court has found was the effect of the alienation of the shares. And 412, to conclude, the tribunal finds that the evidence in the record supports the finding that Mr. Stava continued to control, directly or indirectly, Diag Human after the law book transaction. My respectful submission, it's plainly not possible for the award to retain these findings, given the judgment of this court on the third appeal. The only formulation of relief that is before the court that captures this is the Czech Republic's. My learned friend's approach is simply to look at 413 and amend it so it says Respondent's objection number 5 is dismissed regarding Mr. Stava and upheld regarding Diag Human. In my submission, that would make the award totally incoherent.
Am I right in understanding that each of your formulations, including options A and B, involve the tribunal being forced to adopt the court's findings?
Yes.
And not even being entitled to reconsider its own findings on the evidence it had?
Correct. And that those findings are summarised in Annex 1 of the draft order, so that one can see those in summary. But it's an important point because if an alternative approach is taken, such as that advanced by my learned friends, the award becomes wholly incoherent. When the only way Diag Human can be an investor is if Mr. Stava controls it. And the paragraphs we've just seen from the tribunal say Mr. Stava controls it and that it is an investor as a result. It would be a form of whiplash to read paragraph 413 as my learned friends formulated, to say that Diag Human is not an investor and not controlled by Mr. Stava. Please do recall...
Would it still be incoherent and impermissible to add a paragraph which said, despite the findings that we made on the evidence before us at paragraphs 396 to 413, on the findings that the court made, it has determined that there is no jurisdiction vis-à-vis Diag.
For the tribunal to add a paragraph along those lines.
To vary the award so that reflected what had in fact happened, and would that still be incoherent or not?
With respect, my lord, I think it would be. If one were to be reading paragraphs 408 and 410 to 412, where there are clear findings saying that Mr. Stava controls it, that's the factual reality, and then to see a paragraph either 413 as amended by my learned friends, or with respect to the formulation that your lordship has suggested, it would be an incoherent award in my submission. That type of patchwork is also one which, with respect, the court does not need to do. A variation of the kind the Czech Republic has proposed is one that achieves the position more clearly and allows the Annex 1 findings, which reflect this court's judgment, simply to stand as the correct description of the jurisdiction of the tribunal.
But it imposes on the tribunal findings of fact, which it not only didn't make, but might not even have been entitled to make on the evidence before it.
And my lord,
which is slightly odd, isn't it?
Well, my lord, as we've engaged with, sometimes oddities like that will arise in cases like this, where, for good or ill, Section 67 allows that de novo review, including the admission of new evidence. So it's one of the perhaps slight invidious positions that tribunals will find themselves in when that type of supervisory jurisdiction is exercised. But what is not, in my submission, the correct way to account for that is to vary or rewrite an award such that there are, with respect, incoherencies in what the tribunal has said and then what the court tries to insert by way of patchwork. And the reason I call it patchwork is that ultimately what the award needs to reflect is the jurisdiction of the tribunal. And the simplest way forward in my submission is either a variation on the Czech Republic's primary case or simply setting aside paragraphs where that's possible, which is the Annex 2 paragraphs. So that type of attempt to rework, my lord, I think would not avoid the problem that I am articulating. One point I should also emphasise here is the one I touched on earlier this morning, which is that Mr. Justice Foxton was clear that these paragraphs applied to both of the claimants. That's at paragraph 250 of the August judgment. Indeed, his lordship there said that the application to both claimants was crystal clear, in his words. And so in those circumstances, the point around severability, I suggest, is very strong in relation to these paragraphs. It is impossible to pick out the good parts of these findings between paragraphs 395 and 413 compared to the bad parts. So in those circumstances, the appropriate approach is the one that the Czech Republic is proposing. Now, the defendants do try and make some running in their written submissions that before his lordship, the Czech Republic offered a different interpretation of these paragraphs, such that they may not be read as dealing with both claimants at the same time. However, ultimately, that's not what the judge found, and his lordship's reading has not been appealed in this court. But in any event, if one were to think that these paragraphs are to be read as not dealing with both claimants, that really makes it easier to replace the findings and means variation is appropriate. Now, before I leave jurisdiction paragraphs, there were 2 points I was going to make. The first was about the first sentence of paragraph 414, but I've made that point earlier this morning and I won't repeat that submission. The second point is just to address briefly a point that the defendants make. At paragraph 26.1 of their 6 June submissions, so these were the second lot of submissions in response to the court's email. My learned friends say that when Mr. Justice Foxton was deciding issue estoppel, he said that the issue in respect of Mr. Stava decided by the tribunal was not the same as the issue in respect of Diag Human to be decided by him. With respect, this point around issue estoppel does not take my learned friends forward at all. The legal issues as to Mr. Stava are different, but the defendants cannot explain how Mr. Stava, having alienated his shares by placing them into trust, can claim in damages, if the tribunal had bifurcated jurisdiction and merits and adopted this court's analysis of control at the jurisdiction phase in relation to Diag, it could not then have proceeded to the merits in relation to Mr. Stava on a completely contradictory analysis. Now, that is a material point for present purposes and shows in my submission that there is no serious basis on which one can say that these jurisdiction paragraphs in the award should stand, as the defendants propose. They deal with both claimants at the same time. No issue of estoppel arises out of them, as Mr. Justice Foxton held, and for the reasons I've explained, they ought to be buried as clearly contradicted by this court's judgment. Coming then to the merits paragraphs of the award, so this is the first grey line in Annex 2 of the Czech Republic's draft order. The essential point here is that it's inevitable that the reasoning of this court in relation to control means that there can be no breach after that time. Now, critical to this is the fact that we have touched on this morning, which is that Mr. Stava was not a party to the commercial arbitration, the 2008 award, or the 2014 resolution. So if Diag is not an investor under the treaty, Mr. Stava had no connection at all with the commercial arbitration, the 2008 award, or the 2014 resolution for the purposes of the BIT. That point is an important one because it shows that there is a necessity, in my respectful submission, for the paragraphs in the merits and damages part of the award to be set aside at a minimum by this court. Indeed, in relation to merits, only 8 paragraphs need to be addressed, and even then the affected text within that paragraph is minimal. Can we just turn to paragraph 754 of the award? I hope you still have it open. I'm sorry about that, my lord. Operator, I wonder if you can put up.
What page is it? And I've only got extracts of the award in my supplementary bundle.
There's a supplementary bundle for this hearing, which should have the complete award.
And that has a complete copy of the award, but the operator has put up the award on the screen. And my learned friend helpfully says SB 23.
My mistake, thank you. I'm with you now.
So paragraph 754 is the first merits paragraph to be amended. And you'll see in the draft order we say that it ought to be varied to insert after the entire review proceedings in the penultimate line the words until June 2011. And then to delete the next clause in the sentence being and the 2014 resolution. So quite a minor variation. And it's giving effect on the merits to what this court has decided in the control appeal. Very similar edits then apply.
I don't see that we've decided that at all.
Oh, so pardon me, you're quite right, sorry, I was 2 steps ahead of myself. In our submission, the court's decision in relation to control and the fact that Diag Human is not an investor means as a necessity in our submission, this edit to paragraph 754 to the merits ought to follow. And the reason for that is that at a minimum, if Mr. Stava did not have control of Diag Human after 2011, then Mr. Stava obviously cannot benefit from any alleged breach of the treaty after that time. And so the 2014 resolution, to which he is not a party, to which he is not, which is not addressed to him, must necessarily fall away because it is post-2011 conduct. And for clarity, we have suggested insertion of the words until June 2011 after the words entire review proceedings. So we say that as a result of the court's finding of jurisdiction in relation to Diag and control, post-June 2011 conduct in the merits part of the award ought to be varied, or at least this part set aside on our alternative version of the draft order.
I'm just not following that. what we decided was that under the terms of the treaty, that so far as control was concerned, which is a treaty requirement, so far as the company is concerned, it was not fulfilled after 2011. And that has the jurisdictional consequences in relation to the company's claim. We didn't decide anything about how control or anything to do with control affected Mr. Staver's jurisdiction to make a claim.
No, and I quite accept that, my lord, and I didn't misspeak earlier to suggest that the court had decided the point. My submission is that...
Was it implicit in what we've decided vis-a-vis Diag?
my submission is that the unavoidable consequence of that finding on jurisdiction is that there can be no merits breach in relation to Mr. Staver after June 2011.
Isn't that directly contrary to what the courts have found in relation to the ability to make that argument jurisdictionally against Mr. Staver? Ultimately, all the jurisdictional bases, ratione temporis, vis-a-vis Mr. Staver, have failed, haven't they? Or is that too simplistic a way of looking at it?
Well, I think, with respect, my lord, that is too simplistic a way, because having found that there is no jurisdiction in respect of Diag, such that it drops out as an investor, that then has an effect on what types of breaches can be said to apply in relation to Mr. Staver. If he no longer has any interest in Diag Human, he's alienated the shares from June 2011 onwards, then events that post-date June 2011 are not events that he can say he has an interest in and therefore are breaches of the treaty. So the consequence...
I'm not sure that's right, Mr. Baston, because if the effect of what happened in 2014 is to deprive somebody of a valuable asset in 2008, then it's plainly material.
With respect, my lady, if one has given away that asset in the interim,
After the event.
After
the damage is done in 2008. And,
Well,
and the damage is done as a result that what's happened is that effectively what happened in 2014 has impaired the ability to do anything about the 2008 award, to which he is a privy, not a party.
With respect, my lady, I would not agree that the damage has been done in 2008, because 2008 is a relevant time point, because that's when the commercial arbitration award was issued.
Right.
So in those circumstances, taking simply the issuance of the 2008 award alone, there is not said to be a breach simply by issuing the award or wrongful conduct as a result of the commercial arbitration issuing the award. What is said to be a breach by the arbitration claimants is that conduct in the review proceedings culminating in the 2014 resolution, that was wrongful conduct in breach of the treaty. And the point that we are making is that for conduct that comes after 2011, when Mr. Staver alienated his interest into the trust, that is conduct that he can no longer say is a breach that is within the jurisdiction that he has in front of the tribunal. So I think that we're perhaps slightly at cross purposes, my lady, but it wouldn't be correct to say that there is wrongful conduct which has done the damage in 2008 in the form of the issuance of the 2008 award. Now, my learned friends and the arbitration claimants do say that there is pre-2011 conduct that is a breach of the treaty, but that's the issuance of the Boyar letter back in 1992. It is the review proceedings and the 2014 resolution, which we say post-dates 2011, which is the other category of breaches that the arbitration claimants relied on and proved in front of the tribunal.
This all comes back, as I see it, to your submission that because we have held that there is no jurisdiction over Diag, therefore the merits findings concerning Mr. Staver's claim, which are linked with the reason why we have held that there is no jurisdiction over Diag, must be set aside. Is that
It's a slightly different point, my lord. The linked with is the separability point.
Yes.
And where a bad part of the award is inseparable from a good part of the award, it falls altogether.
Well, you say the bad part of the award is that the tribunal held that Mr. Staver continued to have control after 2011, and we have held on the findings, on the evidence in court, that he didn't.
Yes.
And And that, you say, is what gives rise to setting aside the merits findings made in respect of Mr. Starver, which you say would not have been made if the tribunal had adopted our analysis of the control issue.
Correct. That's exactly so, my lord.
And that's your point. If that's right, well, it's all going to go back to a different tribunal to see whether Mr. Starver's got a claim, and if that's wrong, then the award in favour of Mr. Starver stands.
You have the point, my lord.
And to some extent, what we've got above in the first half of Annex 2 is really tinkering. It's what's below the shaded line that matters, which are 1025 onwards, which are the relevant bits which address Mr. Starver's claim.
You have the point, my lord. We do say it is tinkering in the merit side, just to account for the point that my lord, Lord Justice Bowers, articulated. And you remember that the bottom half or so of the first chunk on that page is to allow the tribunal to determine claims that it didn't determine. Exactly. So then coming then to the second part of Annex 2, which is the damages, interest and cost part of the award. I think you, my lords, my lady, have had my submissions when it comes to the Czech Republic's position that these ought to be varied so that Mr. Starver is entitled to nil and that the court is entitled to do that. However, I hear what my Lord Justice Mayles indicated this morning as to the list of key points, so I will move to make submissions on the set aside.
Are you in good time to finish by 1 o'clock?
I think I am, my lord, thank you. I have only a number of points on this section, and then just it's really 2 categories of points on the disputed points, so I'm grateful for that time check. Now, the court will no doubt remember that there were 3 breaches held by the tribunal. The first was the sending of the Boyar letter in 1992, which was alleged to have damaged the business. The second was interference in the commercial arbitration, but that was held to cause no damage. And third was interference in the review proceedings culminating in the 2014 resolution. Mr. Starver's ability to recover damages for those breaches depends upon his having an interest in Diag. The Czech business, which the tribunal held was damaged by the Boyar letter in 1992, was the business conducted by Conoco, ultimately renamed as Diag. Now, in 1992, as we've touched on, Mr. Starver owned only a percentage of Conoco, not 100%. Not re-entering that discussion now, only touch on it to say in 2011, he transferred his entire entitlement and no longer had any interest in Diag. So the interference with the 2008 award, if it caused damage to anyone, was damage to Diag as the creditor under the 2008 award, with Mr. Starver only suffering damage derivatively via Diag. Now that's an important point, and his lordship below was certainly alive to it. In the March judgment, operator CB/12/66, at paragraph 190, his lordship was considering the point about whether there, an argument had been put by the Czech Republic that Diag had assigned 30% of the claim to a third party. That was what led to the remittal award that was issued recently. Now, part of the reason why his lordship held the point had been put was based on, and this is quoting from him on the screen, the utter incoherence of allowing Mr. Starver to recover more than the company for which any investment was said to have been made by him, which was affected by the breaches of the treaty which were upheld. Now, this makes entire sense, if I may respectfully say. Mr. Starver gifted the shares into the trust in order to create asset protection and succession management. And given that was his intention, and given the only asset that the company had was the claim in respect of the 2008 award to which only it was party, how can Mr. Starver have a claim to damages in the BIT arbitration that cuts across that arrangement? Now, my learned friends seem to be saying that shareholders can have treaty rights, and that's at their latest submission from the 9th of July at paragraph 7. Shareholders can have treaty rights as holders of shares, but one still needs to show what those rights are, what the asset is that it holds. Here, of course, Mr. Starver has been unable to show that he held an asset after June 2011. Now, in that context, there has been a debate before the judge about the proper interpretation of the quantum sections of the award, which we're going to look at in just a moment. In my submission, it is entirely clear that Mr. Stava cannot remain entitled to an award for payment of the 2008 Commercial Arbitration Award when he was not a party to that 2008 award and had alienated his shares in the company being the creditor to that award. Himself is owed no obligations under the 2008 award, and the company to which such obligations may be owed is Diag, in which he alienated the shares. So can we just pick up, please, in the core of the quantum reason, which is at 10.3.3 to 10.3.4 of the BIT award. This makes good the point, and operator, that's at internal page 316 of the award. Now 10.3.3 makes clear that the only head of damages awarded by the tribunal exclusively was on the failure to pay the 2008 award. For the reasons I've just given, in my submission, these findings cannot logically stand. That's why the Czech Republic's primary case is one of variation, but the alternative, at a minimum, is set aside. And that alternative is appropriate because there is at least a realistic prospect that the tribunal might take the view that Mr. Stava cannot have an entitlement of the kind described at 10.33.
But if that's a good point, that's always been a good point. It's got nothing to do with the subsequent jurisdiction challenges.
Well, in a sense, my lord, it does, because of similar reasons that we've been discussing before, that if the court is with me, that the jurisdiction findings of the tribunal are to be varied in line with Annex 1 of our draft order, then that has these knock-on effects on merits, which is the top half of Annex 2, and also a knock-on effect on damages. Given, as I've said, the tribunal awarded only head of damages 1, which was based on the failure to pay the 2008 award, and said we are not going to consider head of damages 3 because Mr. Stava is not entitled to any more than that. It imposed the ceiling that we were discussing before. It is significant if head of damages 1 no longer becomes logically possible. If Mr. Stava has no interest in the 2008 award directly, as in he's not a party to it, and also he alienated his shares in the entity that did, then in my respectful submission, 1033 is so clearly illogical that it must fall. That's where we say our primary case is variation, but at a minimum, it ought to be set aside and reconsideration. So given that head of damages 1 in my submission is not logically maintainable, that militates in favour of the set aside at a minimum that is set out in the Czech Republic's draft order in relation to the quantum paragraphs 1025 to 1043. Now, as I understand it, my learned friends say that Mr. Stava is entitled to damages for sending the 1992 letter, the Boya letter. We've touched on this point briefly, but I just recall it here given the flow of the logic. We say that Mr. Stava is not entitled for those damages once he has given away the shares in the company that was allegedly damaged by those actions. That is the basis on which we say that damages could be varied to nil if the court agreed. But whether or not that is correct, Mr. Stava cannot say that any entitlement to damages he has regarding the sending of the Boya letter in 1992 would be sufficient to sustain the award as made, where he gets 100% of the damages ordered to Diag under the 2008 award. It's not disputed, as I've touched on, that he did not hold 100% of the shares in Diag at that time and only held 53%. Now, the Czech Republic argued in the arbitration that any damages due for the Boya letter breach had to take into account that Mr. Stava didn't own 100%. Now, that point may actually end up not mattering if in any event one awards the full value of the 2008 award because of interference with that award. But once the award of damages for the 2008 falls out of the picture, as we say it must, consequential on this court's judgment, because he has given his shares into the trust, then the 1992 Boya letter breach cannot by itself sustain the full award of damages as calculated in this part of the award. That is why we say that these paragraphs 1025 to 1043 ought to be deleted, either by variation or set aside. Interest is picked up by the tribunal at 1058 to 1060, which is on page 322. And we say that necessarily that must fall with damages as well. If it's an interest award on top of a particular form of damages that is not available, interest goes as well. And while we're here, one can see the conclusion of the tribunal on damages at 1061 to 1062. That is the penultimate line in our Annex 2 of our draft order, which we say also goes with 1025 to 1043. And then lastly, section 15 of the award from paragraphs 1063 onward concerned costs. The tribunal's reasoning begins at 1082 on page 328 and carries through to 1102. Just in summary, the court can no doubt pick it up. The tribunal ruled that the claimants together could recover 70% of the cost, which was about £1.25 million. And it's agreed between the parties that the cost point in the dispositive paragraph needs to be varied. However, we say that the cost needs to be remitted to the tribunal with the award as varied or partially set aside. And my learned friends say the court should amend the dispositive paragraph so that Mr. Starver simply picks up the entire cost award himself. With respect, I submit that that is unrealistic. The tribunal noted that the cost award depends on all the circumstances. That's a paragraph 1084. It identified the fact that the Czech Republic had been partially successful on jurisdiction was relevant to its cost decision. Plainly, the fact that the Czech Republic should actually have been successful on another objection, which would have defeated all the claims by one of the claimants.
How do you say that this is affected, if at all, by the resignation of the tribunal? You can understand that one might remit a costs discretionary question to a tribunal to see what difference the court's decision might have made, but what's a new tribunal supposed to do? To read into the entirety of the case to see what points might bear with them in exercising a discretion? Or what are they supposed to do?
So in short, my lord, the tribunal is an institutional entity. It is not constituted by particular individuals. It is constituted at any one given point of time by 3 arbitrators appointed by the appropriate procedures. So the resignation of the tribunal over the weekend, in my submission, does not affect the decision as to whether or not to set aside and remit. The mere fact that there are going to be different arbitrators does not change the task from being an objective one, carrying on from the determination of this tribunal of the third appeal, and then the issuance of the consequentials order by the tribunal. So I accept that in many cases, a remission to a tribunal will be back to either the same arbitrators or maybe with only 1 or 2 that have been replaced for whatever reason, and that this is therefore an unusual situation. But the mere fact that the tribunal as an institution is differently constituted with different individuals does not, in my submission, change that the appropriate nature of relief being one of remission and set aside, if that's what the court believes is the correct view.
Can a tribunal which is functus resign? I mean, it doesn't exist at the moment, does it?
It certainly was not functus when the parties filed a request for correction or a request for interpretation within the 30-day period within the applicable rules. So at a minimum at that time, the tribunal was agreed by both parties and the tribunal.
Yes, I'd forgot.
I do just need to drop a footnote here, I'm sorry, my lord, to say that there is a debate that could be had as to whether the tribunal was not functus in that 30-day period, because it still had correction and interpretation jurisdiction. And that is the Czech Republic's primary position that it is maintained elsewhere. I simply dropped that footnote for completeness. Seeing the time, I do just want to end on my points on the draft order by saying that the defendants have sought to characterise what the Czech Republic has done in its draft order as a heavy form of editing of the award. With respect, that is not correct. The jurisdictional paragraphs that we looked at are relatively short, flow in my submission clearly as a consequence from this court's judgment. And similarly, it is only tinkering in the merits paragraph of the award. We certainly understand that setting aside the approach to quantum affects a number of paragraphs, but as I have shown the court in paragraph 1033 in particular, the approach to quantum by adopting head of damages 1 and formulating quantum based on the amount of the 2008 award is unsustainable. So that point simply needs to be considered again now that Mr. Stava is the only claimant with an entitlement. I think, if I may just have 60 seconds of the court's time, just to wrap up on the points of dispute that I anticipate would be the final section of my submissions before lunch. We have covered these points largely in the exchanges with the court. But the first point was, if the court decides not to vary the award, should there be a set-aside or remission? I've touched on the points as to why a set-aside is appropriate. That is a proper exercise in my respectful submission of the supervisory court's jurisdiction. It is not a complex and intricate exercise as my learned friends characterize it as, and there is no presumption in favour of remission, as my learned friend says. That's not reflected in Hussman, it's not reflected in section 67 of the Act, it's not reflected in the DAC report. So in those circumstances, we do say that set aside is the appropriate order for the court to make. The second point that I was going to address in this final section was that if there is to be a remission, on what terms should the remission be made? That concerns the debate at option B of the Czech Republic's draft order. I've explained what option B does and the draft of the scope of remission in paragraph F of option B. We do extend that to the remittal award so that it is scooped up with any reasoning that overlaps between the award and the remittal award, and we say that's an appropriate formulation. The last point I make is that my learned friend's formulation of the scope of remission seeks to add language along the lines of the Czech Republic is not permitted to argue or re-argue directly or indirectly any jurisdictional objection in relation to Mr. Stava. That is opposed by the Czech Republic. It's not at all clear what my learned friends are seeking to forestall there, given that this court has decided on the second appeal that that point is not a jurisdictional point. But in any event, for reasons that I can come back to after I hear what my learned friend says, my submission is the court should be very wary about inserting language that binds the Czech Republic to rely on material only as it stood 3 years ago. The position has moved on, including in the evidence of Mr. Stava himself during the pendency of these proceedings before the courts. Indeed, Mr. Stava below, before Mr. Justice Foxton, materially amended his evidence that he gave in the arbitration, including specifically on points that went directly to quantum. In those circumstances, we say that it would not be in the interest of justice to say that those types of points that have emerged in these proceedings are foreclosed to the tribunal in the Czech Republic in any remission. I can develop that point if my learned friend's submission so require. My lords, my lady, thank you for the extra couple of minutes. Those are my submission.
Yes, it was a bit more than 60 seconds, but
I apologise.
all right, 2:05.
이거는 블록, 블록